Now, we're going to go talk about some other claims. Now, if you're involved in an accident that involves a municipality, such as a school or maybe a local highway department, there's some additional things that a possible plaintiff
where you can run into trouble.
Where you can run into trouble. We can run afoul of the law and affect your case.
Correct.
Now, I'm injured by the fault of a municipality. What are the rules that I have to follow in order to ensure that my personal injury case is not going to be terminated suddenly or to preserve my cause of action?
There are two important limitations in cases involving cities, municipalities, schools. One is the 90-day limitation, which is to file what's known as a notice of claim.
And this is just a simple form
yes.
that's filled out and delivered to the municipality?
It's a two-page form, basically. It's pretty basic, like I said. But it's important to have an attorney do it because if it doesn't have certain elements, the claim could be dismissed very easily by a judge later on when you bring the lawsuit.
Now, there's a purpose why you have to file the 90-day notice of claim against your municipality, and it really is not to protect yourself, but it's to protect the municipality. And
correct.
Can you explain what right the legislator has given the
so they're not prejudiced, basically, so that they can go ahead and collect evidence and interview witnesses and that kind of thing, to give them a fair playing field.
Okay, now they do that usually by having a hearing, I believe. Is that correct?
Right. There's something called a 50H hearing. It's a statutory hearing. It's sort of like a deposition.
Now, if you have an attorney at that time and you're the plaintiff, does he have the right to be at
yes,
that hearing? And
he does.
And even if you don't have one, you have a right to be there?
That's correct.
Okay.
Yes.
So this is an evidentiary kind of thing before the lawsuit begins.
And it's very important. It comes into play at trial. It could be used if you should make a statement at the 50H, and you make a statement at trial that contradicts that, they can use the 50H hearing transcript to impeach you at trial.
Now, just to compare the two things, like an automobile accident or slip and fall, which has a different limitation on when you can begin the action, and the process against your municipality, even if it involves an automobile accident, there's a difference. A regular person, automobile accident, how long do you have to sue?
You have a 3-year statute of limitations to bring a lawsuit, but there are other things that you have to do prior to that.
Okay. What are some of those things?
Well, simple thing, even like ordering medical records sometimes. You want to make sure that you order them well before that because places I've found go out of business or the x-rays get misplaced.
Yeah, I have a similar problem with the case. I lost some MRI films and no one can find them.
That's right. So you want to keep on top of the case from the get-go. You want to, the attorney has to order records all the time. Every couple of months you reorder the records.
Now, to get back to the
right.
time limitation on the municipality, you do the 90-day notice, they do their hearing, there is now a shortened time period. What is?
That's right. The statute of limitations against municipalities is 1 year and 90 days.
Okay, so you need
from the date of the accident.
From the date of the accident, okay. Right. So people have to be aware of that if they're involved in injury at the school or
exactly, because even if it's a car accident where the car is owned by the municipality, that sometimes tricks people because they think they have 3 years to bring the lawsuit.
That's not the case.
They have 1 year and 90 days.
Okay, now
it's an absolute statute. In other words, if you bring it in 1 year and 91 days, the judge has no discretion. It has to be tossed.
Out. Now, I know you also practice in Connecticut. Connecticut plaintiffs don't have this issue regarding automobile accidents, right?
Correct. They're not laden with the no-fault law.
How about with municipalities? Do they have similar restrictions in Connecticut?
Yes, they do.
They do. Okay. Now, we were talking a little bit before. There's a problem that plaintiffs have under New York insurance regulations regarding the minimum amount of coverage most people have on their cars.
Right. I see that as a major problem. If you're involved in an accident and the person who injures you through their own fault has a minimal policy. In New York, you're required to only have $25,000.
Which was upped a few years ago from the $10,000.
From $10,000, yes. And so if you should get very badly injured, you'll only recover $25,000 as a maximum recovery unless the person who injured you has assets.
Okay.
Generally speaking, somebody who has a minimum policy generally doesn't have much in the way of assets.
Because just say a defendant only has a $25,000 policy, but he may own a house that has an umbrella policy. Can that plaintiff that was injured in the accident?
I don't find umbrella policies being applicable when there's a minimum policy because most umbrella policies require a certain amount of underlying insurance, usually a minimum of $100,000.
So, no, some people could be home saying, I have minimum on my car, but I have an umbrella policy on my house, and it may not apply.
A simple call to your insurance agent is really important.
So you should have good insurance coverage despite.
Definitely.
So now there are some things regarding your automobile that you can get. There's a thing, PIP.
Correct. You can get additional PIP protection on your, and this is something that really everyone should discuss with their agent.
What does PIP do for you?
It gives you, in the event you're in an accident, generally you're limited to $50,000, that's the minimum in New York, for medical payments and lost earnings combined. Okay, so if you're out of work, let's say a year, and you lost earnings and your medical bills and you have a few surgeries, you could easily exceed the $50,000. You could purchase additional insurance to protect yourself in that instance.
Commonly known as PIP coverage.
Additional PIP.
Yeah.
It's called a PIP, actually. And you could, additional PIP. You could get up to another $150,000 in coverage.
And it's relatively cheap?
It is relatively cheap.
All right, so that's something people should call their agent, make sure that they're well protected themselves.
Which
don't rely on
yeah, absolutely, because it's not something that people even think of asking.
Okay.
So
now,
this could...
And besides this, there's something else people can do.
Right. There's something called additional sum coverage, underinsurance coverage, uninsurance coverage. If you should get into a car accident with somebody that doesn't have any insurance at all, this protects you because you can make a claim against your own carrier.
Okay.
If somebody has minimal coverage, similar thing applies where you could then make a claim against your carrier because the other car is underinsured for the type of injury that you may have.
Now, people should get this, and we're running a little short on time, but I think we learned a lot.
Thank you for having me.
If anyone wants to contact you, you practice in the Bronx.
And in White Plains.
And also in Connecticut.
And in Connecticut, yes.
Very good. Tom Russo, thank you very much.
Thank you very much for having me.
This is County Reports. I'm Philip Marin.